Good afternoon, good evening, good morning, everyone. Welcome to Investment Immigration Conversations, or today I might call it a chat. We're going to have a short one today. My name is Carolyn Lee, your host, and we are very pleased to be with you today again. I thought I would use our opportunity today to really just sort of give a little tutorial. We've been doing a lot of training here at Carolyn Lee Pllc, training up our incredible new members, as well as our seasoned veterans on all the many changes happening in the U.S. investment immigration space. So in that spirit, I thought I would cover with you all some tools and resources that you can use to look into the very important question of investment immigration. Does it matter where I'm from? And this question, I think, really ties into timing and U.S. investment immigration, and perhaps U.S. immigration writ large. It's such a momentous journey that you undertake when making the decision to immigrate. And that requires a whole lot of planning. And a key component of that is timing. And that is notoriously and is in fact very difficult to pin down. So, and it's very fluid, it changes. So I thought again that it would be helpful to share with you some of the tools of the trade, if you will, in trying to get a sense of what the timing would be like from start to finish, or at least from start to interview or start to approval of your U.S. investment immigration case. Very complex set of considerations, and there are different milestones along the way in the process, particularly on the green card side with EB-5, but let's at least get the conversation started. That's our goal for today. And I don't like to do PowerPoints and presentations, but I think in this instance, a visual and some links and visiting some of these links could be helpful. So here we go. Let's do a little screen share. Okay, so U.S. investment immigration doesn't matter where I'm from. Well, it turns out it does, and sort of silly perhaps, but when I thought about it, I thought it was surprising to think about it in this very simple way. Does it make a difference where I'm from? And indeed, it does. And I thought this very simple matrix might help us break down the analysis points. So we're talking about investment immigration. So we're talking about the E-2 visa and the EB-5 visa. And two additional axes of consideration here are, is the applicant, is the E-2 or EB-5 visa applicant abroad, or are they in the US? Because the process and how long it takes and whether it matters does differ depending on whether you're applying from abroad or whether you're in the US. So if you're an E-2 investor, visa applicant, it does matter whether you're abroad or in the US, and it does matter where you're from. And the variable is specific to the post where you'll be applying from. And you could be applying from the post of your residence. That is typically the place. And you could also apply from other posts depending on the strength of your connections to those other posts. In theory, all the posts can take third country nationals or TCNs or visa applicants who are not resident in that consular jurisdiction. However, it is not only post by post in terms of the availability or the openness to TCN processing, but in the post-pandemic world, it's also become a little bit less predictable than it had been. Some posts just aren't taking third country nationals and aren't even taking some kinds of visa categories. So if you're resident in a particular post jurisdiction, very, very likely that post will take your e-visa application, whether you're a national of that country or no. Beyond that, it is much more contextual. And so you'll want to delve into that a bit more deeply. If you're an e-visa applicant and you're in the United States, does it matter? No, not as much as if you're applying from abroad, which is much more post-specific. But I say no-ish. You don't have the post-specific variability, but you have whether or not you're going to premium process or whether you're going to apply using your plain old Form I-129 without premium processing. With premium processing, USCIS is obligating itself to respond in some way. It doesn't have to be an approval. It could be a request for additional evidence, but USCIS will respond within 15 calendar days. Now, it bears mention at this point that we are assuming a perfect case. We're assuming a case that's got all the merits ticked off, because otherwise, of course, if there are some substantive issues in the case, that could delay things as well, as either the post or USCIS may ask questions about whether the eligibility requirements are met. So we're assuming a perfect case. In terms of the EB-5 visa, there too, it matters very, very much so where you're from and in a different way. In the E-2 context, it was really more geography-based, wasn't it? It's post-specific. In the EB-5 context, it matters where you're from in terms of your chargeability. This is a green card concept. This is where you, the individual green card visa applicant, are chargeable to in terms of the countries around the world. Why does this matter? Because we have a quota system on the green card side, and we have within that larger worldwide quota system for family-based cases and employment-based cases, we have per country quotas as well. And the idea here is that in terms of the per country quota, this goes to the question of where you're from, there is a cap, a max of 7% that any particular visa category will accommodate in terms of taking in nationals from any one particular country. So you can see that where there is more demand than allowed by the 7% per country cap in that particular green card category, there is going to be a scenario of oversubscription or a visa backlog. And we're going to see that in just a moment. We have also this concept of Chart A that tells us where we are in terms of a line, if there is one, and we are applying for an EB-5 visa from abroad. We're going to look at that in a moment. Okay, so if you're an EB-5 visa applicant and you're in the United States, same thing. It matters where you're from because we're still looking at your chargeability in terms of analyzing whether or not there is visa availability in the category in which you're applying, or whether there's a backlog by virtue of oversubscription from other investors from your country. And the other point of reference here that's relevant is looking at chart B in the visa bulletin. I'm sorry, I'm not sure whether I mentioned what these charts refer to. These are tables in the visa bulletin that have the priority date cutoff dates, or the dates that represent where the State Department is in terms of being ready to interview visa applicants in a particular green card category from a particular country. And I think these are concepts that are best described or discussed when looking at the visa bulletin, which again, we're going to do in just a few minutes. In terms of E-2 post-specific interview wait times, I commend you to look at this resource on the State Department website. It will report, at least, in the way that is a report. It's individual cases will differ, right? But you've got some reported benchmark right on the State Department website itself. And so if you go to that link, or if I'll have to double check that before sharing that PowerPoint with our registrants, but you can Google it as well, travel.state.gov visa wait times, and this page should pop up. And it allows anybody, the public, to enter any city. And you will get the reported wait times for an interview visa appointment to be scheduled. So it's reported that if you're applying for a visitor visa, a B1, B2 visa, the appointment wait time after submitting an application, a DS-160 application, is 29 calendar days. Student, F1 or exchange visitor visas, J1, 12 calendar days. All other non-immigrant visas, 9 calendar days. Now, one must take these reported processing times with a grain of salt, and I'm going to bring us back to the PowerPoint. So as a point of comparison, just pulled up 2 posts that I had been looking up for clients just this morning. And you see here, Frankfurt reports, I'm looking at E visas, right? So Frankfurt reports 24 calendar days. Dhaka in Bangladesh reports 35 calendar days. But look at what it reports. A couple of things here about Dhaka. Look at what it reports for visitors visas, 850 days versus 24 calendar days in Frankfurt. That is really indicative of how long it could take to apply for really any visa in Dhaka, even though it's got these other categories for F1s and J1s and all others. It just tells you that that particular post is incredibly backed up, really straining there. The other thing that is, oh, I'm sorry, this is Abuja, not Dhaka, Abuja, but very similar point. Dhaka has a very, very long reported processing time to interview for visitors visas as well. And both have the same point here in terms of all other non-immigrant visas reported time frame that I wanted to talk about in terms of E2 visas, where the applicant is applying at a post where they're resident, but in a country where we don't have an E2 treaty. So these are residents of that post applying for an E visa where the post consular officers don't see E visa applicants very regularly. Those applications are accepted. But I think, the reported processing times there are belie the actual wait time in those situations as well. There's the added complexity of applying for an e-visa at a post that is not, that doesn't have procedures, that isn't used to accepting and adjudicating e-visa applications. In terms of the EB-5 and the visa bulletin and looking at where things are in terms of your ability to apply for an EB-5 visa, you look at the visa bulletin, which is also on the State Department website. And I have these particular websites bookmarked on my browser. If you go to that travel.state.gov site and pull up the visa bulletins, you're going to see the current visa bulletin for the month that we're in and the upcoming visa bulletin for the next month. And you'll see that the State Department's already pulled up, has already loaded the October visa bulletin, and the State Department will load the next month's visa bulletin, usually in the first half of the month before. So the October bulletin is here, and so let's take a look at that. And I recommend that folks read the visa bulletin. It's very informative about the underlying law that the visa bulletin is based on, our quota system. It has a chart related to the priority date cutoffs for family-based applications, and most relevant to us for employment-based and EB-5. So this is the website. Let's kind of drill down and look specifically at what's relevant for us. So if you look at the October visa bulletin, here's chart A. Chart A is what's applicable to applicants who are abroad, who are not in the United States. And I've put a box around the EB-5 categories. First thing that I'll mention, it's not completely on point with our conversation today, but you'll note that we have 4 different subcategories for EB-5. We have the 5th unreserved, we have 5th set aside rural, 5th set aside high unemployment, and 5th set aside infrastructure. These latter 3 categories are created by the EB-5 Reform and Integrity Act of 2022. And these set-aside categories are visa categories within the approximate 10,000 visas that are allocated to the EB-5 category on an annual basis. We have 32% of the 10,000, so approximately 3,200 visas set aside for investments going into these 3 categories: rural projects, high unemployment area projects, and infrastructure projects. And then unreserved is everybody else. More on that probably in another devoted webcast just to the set-aside categories. There's much to say there. And you'll see that in most of the boxes here, we have C. C means current. That means that regardless of when you filed your EB-5 case, you're now ready to be interviewed as long as you're documentarily complete or qualified. As long as the State Department or the National Visa Center, which is the office within the State Department that's doing the work of processing the immigrant visa application, the underlying paperwork, bioinformation, police certificates, work history, and so forth. As long as you're documentarily complete or qualified, you're ready to be scheduled for an interview. You don't need to wait for visa availability except in these 2 boxes. if you're mainland China-born investor, you are not ready for an interview unless you have a priority date that is earlier than this reported date. So your filing date on your 526 petition has to be March 21, 2015 or earlier. Same thing for Indian EB5 investors, and this is new. We haven't had a cutoff date reported for Indian investors for about a year or so, more. This was just announced in the October bulletin, this cutoff date. So Indian investors, and we have a post on our website explaining the significance of this and to whom this really applies. So check that out. For purposes of our discussion, if you're an Indian EB5 investor and you're abroad and your EB5 filing date is on or after November 8th, 2019, then you've got to wait, even if you're documentarily complete. Now let's look at Chart B. Chart B refers to dates for filing. This means that if you're abroad, the State Department will start looking at your paperwork, your visa application materials, because it's gearing up for you to be ready for interview soon. Even though the cutoff date up here is the final action date is about a year earlier, the State Department is going to start looking at and asking you to start submitting your underlying documents, anticipating that you'll be up for interview relatively soon. Now, Chart B has special significance for those who are in the United States and who are eligible to file adjustment of status applications. Now, EB5 investors, again, under the EB5 Reform and Integrity Act, can now concurrently file adjustment of status applications when there's visa availability. This is new. We weren't able to do that before. So if you're an EB5 investor and you're in the United States and you're adjustable, basically meaning you're here in non-immigrant visa status and maintaining that status, then you look at Chart B and you see whether you have a priority date that is earlier than these dates for filing, these cutoff dates. The inquiry doesn't stop there, however, because USCIS announces month to month whether, for adjustment of status purposes and for evaluating visa availability, whether the service is going by Chart B or Chart A. It varies. And so for that information, one goes to this page, USCIS's adjustment of status filing charts from the Visa Bulletin page. And here we will see what the service says it is looking at in terms of whether the service is ready to take that adjustment of status application. And you'll see current month is this month, September. And it says for employment-based preference filings, that's us, that's EB5, you must use the final action dates. You must use Chart A, not looking at Chart B in September. But look at this. Next month in October, USCIS is going to use Chart B dates for filing to evaluate whether or not it will take your adjustment of status application if you're eligible to adjust. So, in a nutshell, it does matter. It matters where you're from, whether you're applying for an E-2 visa application or an EB-5. In the case of the E-2, it's more about where you are. In the case of the EB-5, it's more about who you are. There are some nuances to both of those considerations. So just to give a flavor of it, in the green card context, in the EB-5 context, there's the notion of cross-chargeability. So even if you're born in India or born in mainland, if your spouse is chargeable to any other country, you may be cross-charged to that country and not suffer the effects of being in backlog. I invite you to go to the websites that we looked at today. There is quite a bit of, it's really commendable. The State Department and USCIS in the EB-5 area have posted lots of very useful, helpful information about the process on their respective websites. So start there. And if there are any questions, because this was more of a chat than a full-fledged conversation, we would be very happy to answer any questions that you have, whether you're viewing this live or on our YouTube channel. Do feel free to send over questions to contact@carolynleepllc.com related to this topic of E2 and EB5 visas. Doesn't matter where I'm from, and we will be happy to answer at least some of those questions in some form, whether we send it to you directly or address it in a future webcast. Do feel free also to sign up for our newsletters as well. You can go to our website, carolynleepllc.com, and you can sign up for our newsletter there. We will post on a monthly basis news related to investment immigration, and you can stay abreast of the happenings through our newsletter and also our social media channels on LinkedIn, Twitter, Facebook, and of course our webcasts as well. I noted that I'm just noticing that I did create this one final slide that makes this point about concurrent adjustments of status, which I think we've covered enough. It's a great thing. If there's visa availability in your case, if you have a cutoff date in your EB-5 petition that is earlier than any of these reported, either of those reported dates, then you're eligible to file adjustment. So would definitely encourage folks to look into that and file your adjustments, because there might be retrogression in subsequent months, as there was in October. Thank you, and have a great rest of your afternoon or morning or evening. And we will be sure to come back to you with another topic on U.S. investment immigration very soon. Be well.